All right, let's call the case of Marks versus Sunny's Rooftop Bar to order. My name is Judge Jeff Blank. I've been judging in these competitions for the last 5 or 6 years, in addition to coaching a high school mock trial team. At this time, I'll ask our scoring judges who are serving as our jurors to please look at the 2 buttons on the lower left of the screen and turn off your audio and video. I believe you've already done that. These should remain off until the trial ends, when we'll have some brief comments. You should also have your video set to hide all non-video participants. This means that the only people on the screen right now should be the advocates and myself. So we can have the 2 attorneys come onto the screen at this time. And with that, can we please have our attorneys state their appearances for the record?
Yes, Your Honor. May I begin?
Yes.
My name is Climaco, and I represent the plaintiff in this case, Ethel Marks, on behalf of her deceased daughter, Jessica Marks. I'm also joined by my co-counsel here, Mr. Maitreya Gowda. Now, you're not going to see or hear from Mr. Gowda, but he's going to be running the tech and doing his level best to keep me on track.
Very well. In these challenging times, I think we've all tried to become Zoom experts here. With that, can we have our defense attorneys please state their appearances for the record?
Yes, Your Honor. Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Stuart, and I will be representing the defendant, Sunny's Rooftop Bar, in today's case. I'm joined by my second chair, Hannah Lee.
Good afternoon, Your Honor.
Her audio and video will be off throughout the proceedings of today's trial, but she'll be assisting you with any technical matters.
Hopefully we won't have too many technical matters. We've made it through our first trial this morning without any issue. So thank you for that. Before we begin with opening statements, I know sometimes the attorneys have a few preliminary or housekeeping matters that they would like to address. Mr. Climaco, any preliminary matters for?
Yes, Your Honor, just a few. First, we asked to freely share exhibits once they're already in evidence.
Yeah, I assume no objection to that from Ms. Stuart.
None, Your Honor.
Okay, very well.
We also ask that all objections be assumed to be outside the presence of the jury.
Yes, and again, I assume no objections to that by Ms. Stuart.
No objections, Your Honor.
There'll be constructive sidebars.
And one final thing, Your Honor, we
Yes.
do intend to share an exhibit 2 of Jessica Marks during opening statements. It's not yet in evidence, but we do have a good faith belief that it'll be entered into evidence soon after the proof begins. I just wanted to alert the court and Ms. Stuart about this.
Any objection or comment on that from Ms. Stuart?
Your Honor, we have no objection to that document.
All right, then it'll be allowed to be shown to the jury during opening statement, even though it hasn't been admitted yet. Anything further from the plaintiff?
Not at this time, Your Honor.
All right, any additional preliminary matters from the defense?
Yes, Your Honor. First of all, if at any time you are unable to see or hear us adequately, just let us know.
Hopefully that won't be an issue, but thank you for that. Anything further?
Yes, Your Honor. Secondly, we'd like to invoke Rule 615 that all witnesses are constructively sequestered with the exception of party opponents, and Rule 603 that witnesses are constructively sworn in.
Yes, Rules 615 and 603 will be invoked.
And finally, Your Honor, we'd like to draw your attention to Stipulation 11 that Exhibits 1, 22, and 23 are pre-admitted and can be referenced at any time during today's trial.
Yes, that was part of the pre-trial order that was issued back on June 1st, and those 3 exhibits are already admitted into evidence per the pre-trial order.
Yes, Your Honor. And with that, the defense is ready to proceed.
All right, very well. And once again, we'll remind everyone that everyone should be in speaker view. That button is in the upper right of your screen. And attorneys, please remember to mute your audio when the other attorney is speaking. With that, we can please hear opening statements.
Yes, Your Honor. May I begin?
Yes, you may.
May it please the court, Ms. Stuart, and members of the jury. The signs were there. They just didn't care. It's 11 p.m. on March 24th, 2019, at a small bar in Malibu, California. The owner of the bar has been going back and forth to the same young woman's table all night, serving her drink after drink, round after round. The young woman has 5 drinks within 45 minutes after arriving at the bar. The signs are there. She is obviously intoxicated, slurring her speech, talking loudly, and at one point she even stumbles down the stairs. The owner of the bar sees these signs, and he knows he should cut the customer off. But you'll learn that even though the signs were there, they didn't care. They continued to bring drink after drink until the young woman was too drunk to drive, too drunk to make reasonable choices. That young woman's name was Jessica Marks. Jessica was only 19 years old. She never should have been served a single drop of alcohol to begin with. And you're gonna learn that just a few minutes after leaving the bar that night, she crashed her car off the road and into a ravine. Jessica died. She died with a blood alcohol content 16 times the legal limit. And that's why we're here today, to hold the bar that served those drinks responsible. Good afternoon, members of the jury. My name is Climaco, and I represent Ethel Marks, Jessica's mother. Mrs. Marks filed this lawsuit for wrongful death on behalf of her late daughter against the bar that served her all those drinks, Sunny's Rooftop Bar. Now, we all know it's illegal to serve alcohol to a minor, but as the judge will soon tell you, when a bar serves alcohol to a minor who is obviously intoxicated, then that bar's responsible if the person ends up getting hurt. We will prove that's exactly what happened here. That the signs of obvious intoxication were there, the defendant still served the drinks. As the plaintiff in this case, it is our burden to prove to you that 3 things are more likely true than not. First, that Jessica was a minor. Second, that she was served alcohol while obviously intoxicated. And third, that this alcohol contributed to her death. Nobody will dispute that Jessica was a minor or that her car crashed due to her intoxication. So the only question you have to answer is whether the bar served Miss Marks alcohol while she was obviously intoxicated. We will prove to you that it did. During this trial, you will meet Jessica's best friend, a young woman named Morgan Levin. Miss Levin was at the bar that night too, and she'll describe all the alcohol that the defendant served Jessica. From beer to hard seltzer to hard liquor to a whole bottle of wine. She'll tell you that Jessica was slurring her speech, talking loudly and stumbling, all in front of the defendant's employees. You'll get to see the signs for yourself. We have a video of Jessica from the bar that night, less than an hour before she died. The signs were there. They just didn't care. And that makes them responsible. Which is why at the end of this trial, I'm going to ask that you find the defendant liable. Thank you.
All right, thank you, Mr. Climaco. Ms. Stuart, whenever you're ready, you may proceed.
Yes, Your Honor. The plaintiff just gave you a story of pain. And it's true, members of the jury, words cannot describe the pain that Mrs. Marks's family must be going through right now. But pain, members of the jury, is not enough to convict Sunny's Rooftop Bar. And it's not enough to hide the fact that Jessica Marks set herself up to fail before one drop of Sunny's alcohol touched her lips. Now today you're going to hear about Miss Meta. Miss Meta began running her bar in 2017. You're going to hear that she loves talking with her customers. She loves working with her employees. But you're going to hear that she is committed to safety. She IDs customers under 45. She takes care to look for signs of obvious intoxication, and she cuts her customers off when they've had too much to drink. But you're also going to hear about Jessica Marks. You're going to hear that despite Miss Mehta's safety precautions, Jessica Marks made sober decisions to get around them. She had a fake ID. She had a rental car to drive her to the bar to drink and then drive her home from the bar. Despite Miss Mehta's safety precautions, Jessica Marks made sober choices that led to drunken consequences. Now, the plaintiff has the burden of proof in today's case. That means that they must prove to you by a preponderance of the evidence that Miss Marks was obviously intoxicated, that Sunny's bar saw this and kept serving her, and that contributed to her death. They've got to prove to you by the preponderance of the evidence, which means that it's more likely than not. And while we're going to show that they're not going to be able to do this today, there's another reason that Sunny's bar is not liable for this action. And it's because Jessica Marks's negligence, Jessica Marks's own choices caused her death that night. Her sober choices led to drunken consequences. So today we're going to show you 3 choices Jessica Marks made that night. First, she made the sober choice to drive. See, on the evening of March 24th at her Airbnb, Jessica made plans. She planned to drive to Sunny's bar. She planned to drink, and then she planned to drive home. You're going to see that she never asked to get an Uber. She never asked how expensive a cab was. So I want you to ask yourself, if Miss Marks had ordered a cab or an Uber that night before she started drinking, would we be here today? Second, she chose to lie. You're going to hear that Jessica showed up with a fake ID to get into Sunny's bar. So I want you to ask yourself, if Jessica Marks had not lied and brought that fake ID, would she have been served alcohol? And finally, she made the choice to drink. See, before Miss Marks drove to the bar, she said that she planned to go hard or go home. And you're going to hear that that's what she tried to do. And you'll hear that Jessica Marks's 3 decisions, her choice to drive, her choice to lie, and her choice to drink, all culminated in one drunken consequence. And sadly, that consequence was her death. That's why at the end of this trial, we're going to ask you to find Sunny's bar not liable. Thank you.
All right, thank you, Ms. Stewart. We could just take just a moment to give our attorney Scores and myself just a moment to enter this checks for the opening statement. The rest of the trial will wait till the end, as it involves examinations that need to wait for both sides, but the openings are now complete, so we can check that off right now. And before the plaintiff calls its first witness, I'll just ask everyone to switch to gallery view. That button's in the upper right-hand corner of your screen, and this will allow you to see the attorneys and witnesses at the same time. All right, and with that, Mr. Climaco, if you are ready, you may call your first and I believe only witness.
Yes, Your Honor. The only witness we're calling today is Miss Morgan Levin to the stand.
Very well.
May we proceed?
Yes, you may.
Good morning. Please state your name.
Hi, I'm Morgan Levin.
Could you tell us a little bit about yourself?
Yeah, I'm a college student right now at UCLA, but I'm originally from Philly, so just out here for school.
Do you know a woman named Jessica Marks?
I did.
Would you recognize a picture of her if you saw one today?
Of course I would.
Mr. Gowda, could we show Exhibit 3 on the screen for identification, please? Who is this?
Jessica Marks. She was my best friend.
Your Honor, we offer Exhibit 3 into evidence. The blue portion is all redacted. We're only admitting the photo of Jessica.
All right, any objection?
Your Honor, as long as it's just the photo and the rest of the exhibit is redacted, we have no objections.
And that's how I understood it from Mr. Climaco. So with that caveat, it will be admitted.
When was the last time you saw Jessica Marks?
Yeah, that's Jessica.
And when was the last time you were able to see her?
It was outside of a bar on March 24th of 2019.
What were you doing at that bar?
Well, we were there drinking.
Mr. Gowda, could we put a timeline on the screen to establish the events? Do you remember when you arrived at the bar?
Yeah, I do. It was around 9 o'clock.
And when did you leave?
Right before midnight, so I put it at 11:45 about.
Mr. Gowda, those 2 times now. Now, were you drinking there?
Yes, we were.
Do you have any photos taken?
Yeah, I took a series of photographs actually, at all different times during the night.
Mr. Gowda, exhibits 11 through 16 on the screen for identification, please. Are these those photos you just mentioned, Ms. Levin?
Yes, they are.
Are they fair and accurate?
It looks like it.
Your Honor, the plaintiff offers exhibits 11 through 16 into evidence.
No objections,
Yep.
Your Honor.
Very well, no objection. So 11 through 16, or yes, 16 will be admitted for evidence.
Now, could we also put the timestamps from all those pictures on the screen? Both parties have already stipulated to their accuracy.
Okay.
Thank you, Mr. Gowda. Now, I want to zero in on these first 2 pictures at 9:10 and 9:16. I'm seeing a wine bottle there. Is that right?
Yeah, we ordered a bottle of wine first, actually.
And I'm also seeing a glass in Jessica's hand.
Yep, that's right.
Now, both of those things disappear in the 9:42 picture. Why is that?
Well, we had the bottle of wine. I had 1 glass. Jessica finished the rest, so I imagine that's why it's gone.
She finished the rest. How many glasses was that?
Well, there are about 5 glasses in a bottle, so if I had 1, that makes it 4 for her.
Thank you. And I'm also seeing a tall, white, skinny can at the back of the 3rd picture. What is that?
Yeah, Jessica really liked these things called White Claws. They're a hard seltzer.
We get all that information on the timeline now, Mr. Gowda. Thank you. So by this point, by 9:42, she'd been served 4 glasses of wine and a seltzer. Was she displaying any outward signs of intoxication?
Yeah, so she was looking a little tipsy at that point. Call it buzzed.
What sort of symptoms would you describe?
Okay, well, her eyes started to get red, a little bit watery. She slurred her speech a bit.
Was she displaying those symptoms in front of any employees at Sunny's?
Well, she was acting like that for the whole night. So yeah, they were serving our table a lot.
Are there any specific instances that you remember?
Yeah, there was one. Jessica was going down the stairs, and she fell. Sunny Mehta, the owner of the bar, actually caught her.
When was that?
Around 10 o'clock.
Mr. Gowda, that new information, that little tidbit on the screen, please. Did Sunny Mehta say anything when Jessica fell into him?
Yeah, there was the other bartender right near there. Sunny turned to the bartender and said something along the lines of, maybe we should cut this one off.
Now, that quote on the timeline. Let's return to the photos now, please. So let's look at the 3 photos on the right now. I'm seeing more of those tall, white, skinny clans, those white claws, and it looks like a beer is refilled between 10:57 and 11:32. Do I have that right?
Yeah, that's what happened.
Who were those drinks served to?
Well, the White Claws, the 2 more of them, they were both served to Jessica. She also had that beer.
Okay, now let's go back to the timeline and post up all that information. So now that we've looked at all the photos that you took from the night, do you remember taking any videos?
I did take one, yes.
Your Honor, maybe post Exhibit 10 on the screen for identification.
Yes.
Mr. Gowda. Does this look like the first frame of that video you took?
Yeah, it does.
Your Honor, the plaintiff now offers Exhibit 10 into evidence.
Any objection?
Yes, Your Honor, I object to hearsay, specifically the statements that talk about how expensive the beer is, how expensive the beer is.
Response, Your Honor.
Yes.
This video in no way goes to the truth of the matter asserted. If I may proffer, Jessica Marks will display signs of obvious intoxication. She's going to be slurring her speech. She'll be tidbitting with her glasses, fumbling a little bit, losing motor control. We're not trying to prove that any of the things that Jessica said in that video are actually true, just to display the signs.
Any
Your Honor?
response? Yes.
If counsel is offering this video just to show Ms. Marks's symptoms and not any of the statements for the truth of the matter asserted, we just ask for a limiting instruction that these statements not be, that the jury is told that these statements are not being offered for the truth of the matter asserted.
Yes, the court will issue a limiting instruction that anything seen in the video is not being admitted for the truth of any statements that we may hear or see in a video. So with that, the objection is overruled.
With that, is Exhibit 10 admitted, Your Honor?
It is, yes.
Okay, we now play that video.
Yes.
Hi everyone, Morgan and I are in Hollywood. We're in a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. You know, I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
When was that video posted to Instagram, Miss Levin?
Excuse me. 11:11.
Okay. New information on the timeline. Now, by the end of the night, were there any other interactions with Sunny Mehta that Jessica Marks had?
There's one that I can remember, yes.
What happened?
Well, Sunny was at our table serving us, and she turned to Jessica and she pointed at Jessica and she was like, I hope this one's not driving.
Okay, that quote and the time on the screen, please. Sunny Mehta said, I hope this one's not driving. Did she cut her off?
No.
What'd you have?
Well, it was before our last round of drinks, and that was the shots, the green tea shots.
No further questions, Your Honor. Thank you, Ms. Levin.
All right, thank you. Cross-examination, Ms. Stewart.
Yes, Your Honor. Good afternoon, Ms. Levin.
Good afternoon.
Now, we can both agree that Jessica Marks's plan on March 24th was to drink at Sunny's bar, right?
Yeah, that's why we went to the bar.
But after you and Miss Marks agreed to drink that night, at no time did Miss Marks ask if one of your friends from UCLA could be your designated driver.
No, I don't remember her asking that.
At no time during that night she asked how expensive getting an Uber to and from the bar would be.
No, she didn't ask that either.
Or how expensive a cab to get to and from the bar would be.
Nope.
Miss Levin, to your knowledge, the only plan Jessica Marks had was to drive her rental car to the bar and then drive it home from the bar.
I couldn't say what her plan was, but she did drive it there, and she did start to drive it back.
And as far as you know, the only plan that Miss Marks talked about involved her drinking and driving.
Objection, Your Honor, speculation. The witness has already testified that she has no knowledge of the mindset of Jessica Marks. There's been no requisite foundation laid to show that she would have that knowledge. And now Ms. Stewart's just asking the witness to know if Jessica Marks was drinking and driving?
Your Honor, may I respond?
Yes.
Your Honor, this would fall under Miss Levin's rational-based perception. I already asked Miss Levin if she had any knowledge of any other plan that Miss Levin had, and I'm asking Miss Levin that, to her knowledge, the only plan Miss Marks had was to drive there and drive her rental car there and to drive her rental car back.
A response, Your Honor?
Yeah, briefly.
The witness has zero recollection or zero knowledge of what really transpired in terms of Jessica's mindset and the plan that she had. For Ms. Stewart to say Jessica Marks's plan was to drink and drive, well, the witness can't testify to that.
All right, based on the previous two responses and the way this question is phrased, the court will overrule the objection. If the witness is unable to answer the question, she can so state.
Ms. Levin, I'll re-ask the question. To your knowledge, the only plan that Jessica Marks had was to drive her rental car to the bar and drive her rental car back.
Look, there really wasn't a plan, so I couldn't say yes to that question.
But Ms. Levin, at no time during that evening did Miss Marks mention any other plan to get home.
She didn't mention any plan at all, really.
All right, well, part of the plan that night was to bring a fake ID, right, that had her face and the age of 21 on it, right?
We had our
Objection,
IDs
Your
with
Honor. This is not relevant. Whether or not the IDs were brought to Sunny's bar, and we also have laid no foundation that these IDs were actually brought to Sunny's bar. Whether or not those IDs were brought goes no weight to whether there was obvious intoxication that night.
So you're starting a relevance objection or foundation or?
A
Both.
two-pronged objection, Your Honor. First is foundation that those two IDs were actually brought to the bar that night, and also to the relevance of the IDs being brought.
All right, Ms. Stewart, response?
Your Honor, I believe that this is relevant, as part of the plan that Miss Marks had was to bring these fake IDs to the bar. And this is part of the defense's proposition that had she not brought those IDs to the bar, she wouldn't have been served. In addition, Your Honor, this goes to show both Miss Levin and Miss Marks's truthfulness, as using a fake ID with a fake birthday on it would not be truthful.
And can you, without the testimony being transcribed, can you tell me the exact question that you asked about the bringing ID to the bar?
Yes, Your Honor. I asked Miss Levin that Miss Marks brought a fake ID with her picture and the age of 21 on it.
All right, the objections will be overruled.
Miss Levin, I'll re-ask the question. A part of the plan Miss Marks and you had was to bring a fake ID with her name, her face, and the age of 21 on it, right?
We brought our IDs with us, yes.
A part of the plan that you did have was to drive in a rental car to Sunny's bar.
That's what we did.
And part of the plan Miss Marks had was to go hard or to go home.
Objection, Your Honor, to hearsay.
Your Honor, may I respond?
Yes.
Your Honor, this falls under the hearsay exception, a state of mental, emotional, or physical condition, as we're not talking about, we're showing that Miss Marks had a plan to go hard or go home and that she intended to do this.
Okay, any response to that?
Yes, Your Honor. The statement to go hard or to go home is clearly offered for the truth. The go hard portion refers to Jessica Marks supposedly wanting to go hard and wanting to drink that night, and that she did go hard.
Your Honor, may I respond?
Briefly, yes.
We are offering the statement for the truth of the matter asserted, but this statement falls under the exception of mental, emotional, or physical condition, as this is a statement of intent.
So the argument, Mr. Climaco, is good, but it will be admitted for the limited purpose of the state of her condition, because I think it does have some relevance, to that. So it will be admitted for that limited purpose. So there'll be a limiting instruction. It will not be admitted for the truth of the matter asserted. So the hearsay objection is overruled, but the limiting instruction is given.
I'll re-ask the question, Miss Levin. Part of Miss Marks's plan was to go hard or go home.
That's what she said.
And Miss Lee, could you put Exhibit 6 up on the screen? Now, I'm now showing you what has been pre-marked as Exhibit 6. You recognize this video, don't you?
I do.
And this is a video that Jessica Marks took the night before her death.
Yes, I was there when she took it.
You were there when she took it. Is this a fair and accurate copy of this exhibit?
As far as I can tell, I haven't seen it play yet.
Your Honor, at this time, the defense moves Exhibit 6 into evidence.
Any objection?
No objection, Your Honor.
All right, Exhibit 6 will be admitted in evidence.
Miss Lee, could you play this video for us?
We're going out tonight for a night on the town. We're going to a rooftop bar in Hollywood. Should be fun. Go hard or go home. Not ready to go home.
Oh. Miss Levin, you told the attorneys who deposed you everything you remembered from the night of March 24th, right?
I did.
You told her that Jessica Marks had been drinking alcohol before she went to Sunny's bar.
That's true.
You remember that when she got to the entrance of Sunny's bar that her eyes were bloodshot?
Yes.
That your words started to slur?
Yes.
And that she got louder and more outgoing?
Yeah, this was after the 2 glasses of wine she had had.
And you remember that Miss Marks started showing these traits before she stepped foot into Sunny's bar?
Yes.
But there are a lot of things you can't remember for some reason, right?
Not exactly sure what you mean.
Well, you can remember that Sunny visited your table 8 to 10 times, right?
That's true.
But you can't remember what Sunny was wearing.
I mean, no, it was like 2 years ago.
And you remember that specific things that Miss Mehta said about Miss Marks?
Yeah.
But you can't remember what Miss Mehta's voice sounded like.
Not exactly. The words, not the voice.
You can remember the exact symptoms of intoxication Miss Marks showed, but you can't remember when they started.
It was kind of like throughout the whole night, so I wouldn't be able to give you specific times if that's what you're asking.
So that's yes to my question?
Yeah.
And you can remember the exact times when you left the bar and got into your Uber, but you can't remember specifically how much Miss Marks had to drink.
I remember pretty specifically how much Jessica had.
Oh, you remember how much you had to drink, right, Miss Levin?
I remember that too.
Right, you had a beer, you had wine, and you had a green tea shot.
Yes.
And it's true that you were drinking during all of the things you apparently can and can't remember during that night.
Yeah, I wouldn't say my mind was affected though, if that's what you're getting at.
Now, Miss Levin, it's true that Jessica Marks's mother threatened to sue you for Miss Marks's death.
That's true.
But she never ended up doing that, right?
No.
And Miss Lee, could you put Exhibit 23 up on the screen? Miss Levin, I'm now showing you Exhibit 23, the police report for this case.
Okay.
I'm going to read a highlighted portion of this document to you. Ethel Marks said she understood and would do anything she needed to do to make sure that the bar was held responsible. Did I read that correctly?
You did, yeah.
Now, instead of suing you, she let you speak with the plaintiff for 2 to 3 hours before your deposition, right?
She let me speak? I mean, I spoke to her attorneys. So yeah.
Right, you spoke with them before your deposition.
Yes.
And after you spoke with those attorneys, and when you walked into the deposition room, you told those attorneys that Jessica Marks was, and I quote, obviously intoxicated.
I did say that.
Miss Levin, would it surprise you to know that in this case, we're required to prove that Miss Marks was obviously intoxicated?
That wouldn't surprise me at all.
Thank you. I have no further questions.
Thank you. Any redirect?
No redirect, Your Honor.
All right, with that, the witness may be excused. And now the defense may call its first and only witness.
Yes, Your Honor. The defense calls Sunny Mehta to the stand. May I inquire?
Yes.
Good afternoon, Ms. Mehta. Would you please introduce yourself to the jury?
Good afternoon. Hello. My name is Sunny Mehta.
And how are you involved in today's case?
I used to own a bar called Sunny's Rooftop Bar. And back in 2019, a girl named Jessica Marks came in and we served her. And later that night, she ended up getting into a car crash. I understand I'm here to talk about what I know.
Before we talk about the events of March 24th, I want to talk about your bar. When did you first start owning it?
Sure. I mean, well, growing up, my parents owned a restaurant, a little cafe right outside of Los Angeles. So when I was younger, my sisters and I would always run around, talk to the regulars. When I was in high school, I mean, I started waitressing, was a hostess for a little while, but I think I always knew that I wanted to open up a place of my own. So in 2017, when the property for Sunny's became available, I jumped at it.
What are the safety precautions required to run a bar?
There's quite a few. The main one is that the state of California requires anyone who owns or works at a bar to undergo a certification. It basically teaches you how to handle alcohol responsibly.
And why is this certification important?
Unfortunately, it's a business in which a lot of people can hurt others. So I think the state just wants to make sure that everyone who's part of that business is being responsible, is making sure customers are safe.
And you mentioned the certification. What does the certification teach you?
Teaches us a bunch of things. The importance of not serving people who are underage, but the main thing is really how to notice if someone is too intoxicated or if they've had too much to drink.
And do all of your employees take this course?
Of course, all of us do, myself included, and you have to retake it every couple of years to make sure that you're up to date.
I want to talk about your procedures at your bar specifically. Have you seen these signs of intoxication in people in the past?
Absolutely. It's part of the game when you own a bar. I'd say about once a week or so, we'd have a customer that had a little bit too much to drink.
And how do you respond to those cases?
We check in, of course, try to watch them a little bit more closely. And if they have had too much to drink, then we'll cut them off.
Objection, Your Honor. This is improper character evidence. The evidence is being used to show that in the past, Ms. Mehta has cut off customers and that she'd be more likely to in the future if she saw any signs of intoxication.
Your Honor, may I respond?
Yes.
Your Honor, this falls under the character evidence exception, Rule 406. This is a habit or routine practice as defined in Rule 406. Your Honor, we've laid the foundation for this as we've shown that Ms. Mehta is trained to identify these signs of intoxication, and that she sees these signs of intoxication regularly, and that she makes it her routine practice to cut her customers off when they've been served too much to drink. And because of this, Your Honor, this falls under Rule 406.
A response, Your Honor?
Yes.
Rule 406 is very different than how it's being extrapolated. It's not a habitual thing. It's more of an instinctual thing, i.e. if I get in my car and I drive somewhere, I'm going to put on my seatbelt, but I'm not going to necessarily remember that I put on my seatbelt. 406 allows for admissions of those instances. But this instance is used to show that Ms. Mehta's trait of being careful or stopping all customers who might be obviously intoxicated is more likely to stop them in the future.
Your Honor, may I respond?
Yeah, briefly.
While habit may be an instinctual practice, routine practice is not. Now, Ms. Mehta makes it her routine practice in her business to regularly identify customers who've had signs of intoxication and to stop their drinks.
All right. The court's going to sustain the objection. There seems to be just too many different variables between different circumstances to apply Rule 406 exception here.
Ms. Mehta, I want to talk about the night of March 24th. Specifically, what signs of intoxication you saw in Jessica Marks. What time did Ms. Marks come in?
I'd say it was around 9 p.m.
And who was she with?
She said it was with a friend, Morgan Levin.
When she appeared, did Ms. Marks show any signs of alcohol drinking?
No, neither of them did. They seemed sober to me.
And did you ID them?
Not immediately. I mean, they hadn't ordered any alcohol yet, but once they started ordering, yeah.
And did you interact with Jessica and Morgan frequently throughout the night?
I mean, I was their server that night. We were kind of short-staffed, so I was the only one bringing drinks out. Between taking orders, bringing drinks, clearing tables, probably interacted with them 8 to 10 times that night.
And how often would those interactions be?
Um,
I'm sorry, how long would those interactions be?
Probably 30 seconds, a minute max.
And did you see Jessica show any signs of obvious intoxication during your visits?
No, ma'am, nothing like that.
Now, were you in the room for Miss Levin's testimony?
I was. I didn't have my camera on, but I've been watching. I've been listening.
She talked about a time when Jessica Marks stumbled into you on the stairs. Did this ever happen that night?
No, ma'am. I heard her talking about that, and that didn't happen.
And when was the last time you saw Jessica Marks?
A little before midnight. I think her and Ms. Levin left. I watched Jessica come down the stairs and walk out the door.
I want us to talk about those stairs for a minute. Miss Lee, could you put up Exhibit 9 on the screen? I'm now showing you what has been pre-marked as Exhibit 9. Do you recognize this document?
Of course, I'd recognize it anywhere. Those are the stairs at my bar.
And is this a fair and accurate copy of this document?
Looks to be, yeah.
At this time, Your Honor, the defense moves to enter Exhibit 9 into evidence.
Any objection?
No objection, Your Honor.
All right, Exhibit 9 is admitted.
What was Jessica Marks's demeanor as she walked down the stairs?
I mean, it didn't seem like anything out of the ordinary. Her friend was a little wobbly, but I thought Jessica seemed fine.
I want to talk about Morgan Levin. Did you see any symptoms of alcohol effects on her during the night?
Yeah, sure. I mean, she certainly seemed a little buzzed. I noticed that her breath smelled a little bit like alcohol. Like I said, she seemed a little wobbly, but nothing.
Objection to relevance, Your Honor.
Your Honor, may I respond?
Yes.
This testimony goes to the credibility of Morgan Levin. It's the defense's argument that Morgan Levin had been drinking that night and that her judgment may have been affected. And because of this, Your Honor, we believe that this testimony is relevant as it goes to show the credibility of Morgan Levin.
Your Honor, a
Yes.
response?
Yes.
First, Ms. Mehta's only claimed that she was a little bit buzzed. To no extent has she claimed that Morgan Levin was so impaired that she wouldn't be able to remember anything. Second, there's no foundation laid that even if she was a little buzzed, that she wouldn't be able to remember the events of the night.
Your Honor, may I respond?
Yeah, briefly.
Counsel's argument goes to weight and not to admissibility, as Morgan Levin's symptoms throughout the night translate directly to her truthfulness.
The court tends to agree there may be a limited relevancy here, but the argument can go to weight and not admissibility, so the court will overrule the objection.
Ms. Mehta, did you know who was driving home that night?
I did, yeah. Probably around 11. I wanted to check in with their table. Like I said, Morgan seemed a little bit buzzed, so I just wanted to make sure everyone would get home safe. And that's when Jessica reassured me that she was going to be driving home.
And how did you react to this information?
I mean, I guess I was relieved that it wasn't Morgan. I mean, Jessica seemed fine to drive, so I thought it sounded like a good plan.
Ms. Mehta, Ms. Lee, could you put Exhibit 23 up on the screen? Ms. Mehta, I want to talk about what Jessica Marks's BAC was at the time of this incident. Ms. Lee, could you put up this highlighted portion of this document to me? Ms. Mehta, read along with me. Mrs. Marks's BAC at the time of the crash was 0.16. Did I read that correctly?
Yeah, it looks like it.
Were you in the room for Morgan? You said you were in the room for Morgan Levin's testimony. Do you remember how many drinks Morgan Levin said that Ms. Marks had that night?
I think she said it was about 8.
And how many drinks did you see Ms. Marks drink that night?
To be honest, not very many. I mean, I was serving drinks to their table. We had a lot of other customers.
Objection, lack of personal knowledge, Your Honor. The witness can't testify to how many drinks Jessica Marks had because Miss Meta wasn't at the table the whole time.
Any response?
Your Honor, again, I'm just talking about what this witness's present sense is her impression of how many drinks Miss Marks had that night based on her own personal knowledge.
I think as the question was phrased, the objection is sustained.
I'll rephrase the question, Your Honor. Ms. Meta, how many drinks did you see Jessica Marks order that night in relation to Morgan Levin?
I thought they both ordered each time I came around, so probably the same number.
Ms. Meta, I have a few more questions for you.
Okay.
Who ordered the drinks that night?
I think they both did, Morgan and Jessica.
And who showed their IDs that night?
That also must have been both of them.
And who drove home?
I think Jessica was the only one that drove home.
Thank you. I have no further questions.
All right, thank you, Ms. Stewart. Mr. Climaco, any cross-examination?
Yes, Your Honor. May I proceed?
Yes, you may.
Ms. Meta, I'd like to talk about the duties of a bar owner. You'd agree, as you said on direct, that bar owners have certain obligations under the law, correct?
Absolutely, yeah.
And as you told this jury, you were trained by the state of California on those obligations.
I was, yes. I took a training course, got my certification.
For example, one of the things you mentioned was that you can't serve alcohol to minors, right?
That's correct, sir. Anyone under 21.
The same way you can't serve alcohol to any person who is obviously intoxicated. I got that right?
Yep, you do.
And you were aware of those obligations on the night of March 24th, 2019, the night that Jessica Marks walked into your bar, right?
I was, sir, yes.
But you still served her drinks, didn't you?
Yes, sir, I did.
And you never cut her off?
No, sir, I never saw anything that indicated to me she needed to be cut off.
Well, I keep hearing that. You saw no indications of obvious intoxication. You brought 7 individual drinks to Jessica Marks's table, right? Including liquor, beer, seltzer.
That's true.
Even a whole bottle of wine.
That's correct, sir. I brought that to their table.
And you're aware that Jessica Marks died less than 10 minutes after leaving your bar, right?
That's what I heard, sir. Yeah.
And as we saw, she died with a blood alcohol content of 0.16.
That's true, sir.
Now that's 16 times the legal limit for a minor, isn't it?
Yes, sir, it is.
But even with all those drinks that got her to 0.16, you'll at least admit she became more inebriated over the night, right?
Sir, if she did, I mean, I didn't notice it. I didn't see any signs.
It's your claim to the jury that despite serving 7 individual drinks and a whole bottle of wine during the night, you didn't see her become more inebriated?
Sir, she never seemed inebriated, never seemed drunk to me. That's true.
Right, so you would call her perfectly sober, wouldn't you?
No, I mean, I could see that she was drinking. I mean, like you said, I was serving drinks to her table, but she didn't seem drunk, no.
You wouldn't call her perfectly sober?
No, of course not.
Just to be clear, your testimony to this jury is that you are not calling Miss Marks totally sober, perfectly sober.
She seemed fine, but I mean, I knew that she was drinking. That's correct, sir.
Mr. Gowda, do you have the testimony on hand? That's fine. I actually have it on hand. Here we are. Now, Ms. Mehta, read along silently as I read aloud. When you first saw Jessica Marks at 9 p.m., did she appear obviously intoxicated? No, she looked perfectly sober. Her face, walk, everything. Totally sober. Did I read that correctly?
Yes, sir. I mean, she looked perfectly sober, absolutely. But I knew she had a couple of drinks.
That's fine, Mr. Gowda. Could be play exhibit 10 on the screen, please.
Morgan and I are in Hollywood. We're in a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. You know, I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Ma'am, you'd agree she looks obviously intoxicated in that video, wouldn't you?
No, sir, not obviously intoxicated.
If not obviously intoxicated, then at least buzzed, right?
I mean, sure, she definitely looks like she could be.
It's still your claim to this jury that the only thing you saw was Jessica Marks perfectly sober?
Yes, sir. I mean, she seemed fine to me.
That's not what you told the cops, though, was it?
I'm sorry, sir. I don't remember what I told the police.
Mr. Gowda, Exhibit 23, please. It's already in evidence. And read this highlighted portion along with me silently as I read aloud. You said, I spoke to Sonny Mehta, the bar's owner. Sonny said that Jessica Marks was a typical buzzed girl. You didn't tell him she was perfectly sober, did you?
That's true, sir.
So you're telling us that you described her as perfectly sober or as buzzed in the video? And now you described her as buzzed to the cops that night? You're telling us you never saw the sign she displaying in the video that night?
That's true, sir. I mean, I wasn't around her for very long.
But you'd agree you used the same word to describe her in the video as you did to the cops.
Sure. I mean, it looks like she could be buzzed.
No further questions, Your Honor.
All right, thank you. Any redirect?
Miss Mehta, you said that Miss Marks was perfectly sober. At what time did you see her perfectly sober?
I'm sorry, ma'am. I don't remember an exact time. I just remember that throughout the night, she seemed fine to me.
Thank you.
All right. Any further questions? No recross. May the witness be excused.
No recross, Your Honor. I think the point is clear.
Okay. This witness will be excused then. And I'll give our scoring attorneys an opportunity to enter the scores for the witnesses now that the witness presentations are complete. So we can take just a 1 minute pause here, get up to speed before we begin closing arguments. And with that, I remind everyone you should switch back to speaker view for the closing arguments, which will begin in about 30 seconds. All right, well, with that, we can proceed to closing arguments. Whenever you're ready, Mr. Climaco, you may begin.
Yes, Your Honor. May it please the court, opposing counsel, and members of the jury. When this trial began, I told you that the signs were there. They just didn't care. And that's exactly what the evidence proved today. On March 24th, 2019, Sonny's Bar served a 5-foot-tall, 19-year-old woman 4 glasses of wine, 3 hard seltzers, a beer, and a shot, all in just over 2.5 hours. That's 9 drinks. The defendant served her so much alcohol that her blood alcohol content was 16 times the legal limit when she crashed her car and died. And yet the defense wants to believe that Jessica Marks wasn't obviously intoxicated, that she was making sober choices. Members of the jury, that's both not true and not good enough. The signs were there. They just ignored them. But the law in the state of California doesn't allow Sonny's bar to ignore the signs, because it was the defendant's duty to protect its customers, to protect minors like Jessica Marks. It was the defendant's responsibility under the law to ensure that it didn't serve alcohol to an obviously intoxicated minor. The defendant ignored that responsibility, and Jessica died as a result, which is why we brought this claim for wrongful death. So let's talk about what we proved today. It was our burden to prove that 3 things are more likely true than not. First, that Jessica was a minor. Second, that the defendant served her alcohol while she was obviously intoxicated. And third, that this contributed.
Oh, can we stop you there? Looks like we've lost audio here. Restart it.
Of course, Your Honor. May I re-begin?
Yes.
Okay. May it please the court, opposing counsel, and members of the jury. Now, when this trial began, I told you that the signs were there and they just didn't care. I told you it again in the first version of this closing. Now, that's what the evidence proved today. On March 24th, 2019, Sonny's Bar served a 5-foot-tall, 19-year-old woman 4 glasses of wine, 3 hard seltzers, a beer, and a shot. That's 9 drinks. The defendant served so much alcohol that her blood alcohol content was 16 times the legal limit when Jessica crashed her car and died. And yet the defense wants you to believe that Jessica Marks wasn't obviously intoxicated, that she was making sober choices. Members of the jury, that's both not true and not good enough. The signs were there. They just ignored them. The law in the state of California doesn't allow Sonny's Bar to ignore the signs because it was the defendant's duty to protect its customers, protect minors like Jessica Marks. It was the defendant's responsibility under the law to ensure that it didn't serve alcohol to an obviously intoxicated minor. That choice, that ignorance, is the reason why Jessica died. And that's the reason we brought this claim for wrongful death. So let's talk about what we proved today. It was our burden to prove that 3 things are more likely true than not. First, that Jessica Marks was a minor. Second, that the defendant served her alcohol while she was obviously intoxicated. And third, that this contributed to her death. As you know, Jessica was 19, and she was served alcohol by the defendant. That alcohol led to her crashing her car while intoxicated and dying. None of that's in dispute. So the only question left for you to answer was whether the defendant served Jessica when she was obviously intoxicated. We proved they did. Let's return to the testimony of Morgan Levin and the timeline of events from March 24th. Morgan Levin told you that Jessica Marks had 5 drinks within 45 minutes of arriving at the defendant's bar. Unsurprisingly, she started to slur her speech, talk loudly, and lose muscle coordination. Around 10, she tripped into Sonny Meta herself. And this is very important, members of the jury. The defendant's owner said, we might need to cut this one off. Why would she say that? Because Jessica Marks was obviously intoxicated. Now, of course, she denies saying that today. Because if she admits saying it, she's liable. She loses. The signs were there. She just didn't care. She continued to bring drink after drink after drink, seltzers and beer and shots until it was too late. So think back to the video of Jessica. You got to see the signs of intoxication for yourself. Glasses crooked, slurring her speech, unsure which drink to even grab. She was obviously intoxicated in that video. Now, the defendant would have you believe that she never saw Jessica in that condition, but we know that's not true. Today, under oath, the defendant couldn't keep her story straight. She described Jessica in that video as buzzed. Members of the jury, that's the exact same description she gave the police on the night of Jessica's death. Not perfectly sober, buzzed. A typical buzzed girl. Now, regardless of the defendant's definition of buzzed, why did she use the same description for the video and for Jessica that night? Because the video shows exactly what she observed. An obviously intoxicated minor. The defendant just didn't care. And they didn't do their job. So members of the jury, let's talk about your job. The judge is going to instruct you on the law, and it will be your duty to fill out this form. Because we have proven that Jessica's death was caused by the defendant serving her alcohol when she was obviously intoxicated, you'll mark yes to question number 1. Finally, you'll need to answer a question about this idea that Jessica somehow caused her own death, that she was making sober choices. For the jury, when Jessica decided to drive after leaving Sonny's, her BAC was 16 times the legal limit. By over-serving an obviously intoxicated minor, the defendant deprived Jessica of any ability to make a reasonable choice, a sober choice, which means you'll mark no to question number 2 and your job will be done. Now, members of the jury, I'll get to speak to you again after Miss does. For now, just remember that the signs were there and they just didn't care. Find the defendant liable. Thank you.
Thank you. Ms. Stuart, whenever you're ready, you may proceed with the defense's closing argument.
Members of the jury, the plaintiff would have you believe that Miss Mehta was the only actor in this case. But members of the jury, there's another actor that was legally required to show care. That actor was Jessica Marks. See, her sober choices before she even stepped foot into that bar led to her drunken consequences. Now, the plaintiff has the burden of proof in today's case. And that means that they must prove to you that Jessica Marks was obviously intoxicated, that Sonny's bar saw this and kept serving her, and that was a substantial factor in her death. Members of the jury, they haven't been able to do this today because the evidence that they've given you was faulty and was full of contradictions. So let's take a look at this first contradiction. See, today we heard from the police report that Jessica Marks's blood alcohol content was 0.16. But at the same time, the plaintiff is trying to argue that Miss Marks had 5 to 8 drinks that night. Members of the jury, anyone with experience with alcohol knows that 5 to 8 drinks would not result in a 0.16 blood alcohol content in a 5-foot tall girl. She'd be dead. But let's take a look at what Miss Mehta said about what Miss Marks had to drink. She said that Morgan Levin and Jessica Marks split those drinks evenly. Now that lines up with science, members of the jury. Miss Levin's testimony does not. So let's talk about why her testimony would not line up with the science in today's case. See, today you heard about a wrongful death charge placed on Miss Levin. A wrongful death charge that said that Miss Levin would be liable for Miss Marks's death, but that was somehow dropped. And you heard that after Miss Levin spoke with Miss Marks's attorneys for 2 to 3 hours, she started saying things like obviously intoxicated. Members of the jury, Miss Levin's testimony is too perfect. And that's because the things that she can remember were twisted and informed by a dropped liability charge. Members of the jury, even the things that she can remember, we told her today that she told us today that she had been drinking that night too, and there were many things that she couldn't remember. Members of the jury, all the plaintiff brought you today was an unreliable witness, an out of context video, and pictures that did not tell us exactly what Jessica was drinking that night. They cannot prove that Miss Marks was visibly and obviously intoxicated, and without doing that, you cannot convict Sunny's rooftop bar. What did cause Miss Marks's death? See, if you still believe that Miss Marks was obviously intoxicated, you brought to you today what's called an affirmative defense. So you must ask yourself, did Jessica's own actions, Jessica's own negligence, cause her death? No. I don't think anyone wants to stand up here and blame a girl for her own death. But members of the jury, whether you're 19 or 45, the moment alcohol touches your lips, you assume a responsibility. You're legally required to ask, how are you going to get home that night? And when am I going to know when I've had too much to drink? And Miss Marks made three fatal choices, three fatal decisions that ended up in one drunken consequence. She chose to drive, she chose to lie, and she chose to drink. So first, she made the sober choice to drive, because you heard that today she had planned to go to Sunny's bar to drink. You heard that she planned to take her rental car and drive it from her Airbnb to Sunny's bar. And you heard that she never at any point made plans to get an Uber home, to take a cab home, to find a designated driver. She chose to drive. And so I want you to ask yourself, if Miss Marks had made a plan to get home that did not involve drinking and driving, would she still be here today? And the answer to that question is yes, she would be. And next, she made the sober choice to lie. See, she lied about her age to the bartenders there, and she made the choice to bring a fake ID to that bar. And she chose to use it to get into that bar that night. And I want you to ask yourself, had she not brought that ID into the bar, would Sunny's bartenders have served her alcohol? And the answer to that question is no. Finally, she made the sober choice to drink. See, at the beginning of the night, you heard Miss Marks say that she was planning to go hard or go home. And that is what she did. She was planning on getting drunk at Sunny's bar with no plan to get home. And at the end of the night, when she walked out of that bar, she put her keys into the ignition and she drove home. She made that choice. But members of the jury, this case isn't just about that one choice. It's about every choice that Miss Marks made leading up to her death. Her sober choices led to drunken consequences. See, at the end of the day, it doesn't matter how much alcohol Sunny's rooftop bar served her that night. Because if Miss Marks had done any one of those things before she started drinking, she would not have been able to get into her car that night. She wouldn't have been drunk at all. And if she hadn't gotten behind her wheel, or if she hadn't made the choice to drink, she shouldn't have been killed while drunk driving. Members of the jury, Jessica Marks made sober choices long before she stepped foot into Sunny's rooftop bar. And those sober choices led to drunken consequences. And sadly, that consequence was her death. That's why we ask you to find Sunny's bar not liable. Thank you.
All right, thank you very much. Rebuttal for Mr. Climaco.
Yes, Your Honor. With the complications from the first closing, we don't have the exact time. Does 2:15 sound reasonable to everyone? Or does opposing counsel have a specific time?
Stuart, any objection to
Your Honor,
2 minute?
2:15 sounds fine.
Okay, thank you. We'll allow you 2:15 for the rebuttal then.
Thank you, Your Honor. Yeah. Ms. Stewart spent her entire closing argument proposing an affirmative defense. It's a nice way of saying they're blaming Miss Marks for her own death, blaming the victim for her supposedly sober choices. Members of the jury, the only person making sober choices that night was Sunny Mehta. The sober choice to serve 2 minors alcohol while one of them was obviously intoxicated. They want to talk about contradictions, a case not lining up. Well, the only person who was contradicting themselves tonight was the same answer to the last question. Sunny Mehta, when she claimed that she never called Jessica Marks perfectly sober. Well, you saw it. You saw her deposition. She said those words. And those 3 fatal choices, are that Miss Marks drove, Miss Mehta served, and Miss Marks died. Members of the jury, even if you do think that despite how drunk they got her, that Jessica Marks's decision to drive was unreasonable, your job still isn't done. The defense doesn't just magically win. You have to answer a final question. The question Stuart didn't tell you about. You have to write a percentage of fault next to Miss Marks's name and the defendant's. If you find yourself answering question number 3, mark 90% next to that approachment for the defendant and 10 for Jessica Marks. Thank you.
All right, thank you.